appeal in the matter of THJ Systems Limited and Sheridan and
Yes.
My lords, my lady, I appear for the appellants in this appeal, Mr Daniel Sheridan and Sheridan Options Mentoring Corporation. My learned friend Mr Davis, King's Counsel, appears for the respondents and the cross appellants, THJ Systems and Option Med. The court should have 3 bundles, core, supplemental and authorities bundle in one volume. My Lord Justice Arnold has circulated the right and BTC core decision. I understand my learned friend has several copies of that handy in case it persists. There is also an inserted chronology to tab 4 of the core bundle, I think. It should be at the back of tab 4 already, an additional chronology.
And, well, I'm not sure. How many pages is it?
1 or 2 pages.
It's
39A.
a single page.
39A.
I haven't got that.
No.
No.
Again, Mr Davis.
And could you hand up the authority as well while we're at it? Thank you.
Thank you. Thank you.
Thank you.
Yes.
And on that basis, I propose to start with my submissions on the appeal.
Thank you.
I will start with some brief background points and then move on to the law and then move on to the evidence relating to the appeal.
And you'll deal with a cross appeal in reply? Sort of reply?
I would propose to deal with the cross appeal up front, my lord.
Okay.
Unless my learned friend has any objection to that, or was proposing to do it the other way around.
It's really in my own friends and your lordship's hands. So.
Whichever you... do you mind which one it is? Whichever you...
Well, in that case, I'd be happy to deal with it next time round.
Deal with it what?
Well, my preference would be to do it all at once.
Yes,
if
it would do. Do that.
Very well. Very well. So starting with the appeal, this appeal concerns the learned judge's declaration of copyrights in certain works. And by way of reminder, those works are identified in the order itself. Core bundle, tab 5, page 42.
Yes.
Known as Declaration H.
Yes.
3 works, the graphic user interface, the graphic displays produced by the software when in use, and the one logo. And throughout this case, I regret to say that the parties were rather vague about the exact nature of the works that were being claimed, and that is on all sides, and likewise the exact nature of the infringements. As the court will be well aware, there is a close relationship between carefully identifying the relevant works and identifying what has been copied or infringed. And that lack of conceptual clarity is potentially one reason why we're here on both the appeal and indeed the cross appeal. If we turn to the particulars of claim, this is core bundle 8, page 30, page 8, starting at paragraph 38, which is page 15148. This is where breach of copyright is pleaded. And
sorry, this paragraph number
paragraph 38, bottom
38.
of page 148.
Yes, thank you.
Initially, what paragraph 38 says is the software, including its source code, was created by Mr. Mitchell and so on. So it's a reference to the software in the abstract,
yes,
and to the software in particular. And then there is a series of subparagraphs. 38.1 refers to the software as a literary work.
yes,
38.2 refers to the images produced by the software, including but not restricted to risk and price charts. And this is much of our battleground here today, and I will return to it. But I pause to highlight even here there is a lack of specificity with which these images are identified. It's by a generic category. And then moving on to 38.3, we have a pleading of US.
Just before you move on,
Yes, my lord.
we can see that these are different in character, as it goes on to say each of the images generated by use of the software or the intellectual creation of Mr. Mitchell's author and comprise an artistic work pursuant to section 4.
Indeed, my lord. They are identified here as an artistic work. 38.1 is clear that they're referring to section 3 as a literary work. So that distinction is drawn. And then 38.3, we have the US copyright being pleaded.
Yes.
And as my lords and my lady will have picked up, that was not pursued at trial. While we are on this part of the pleading, infringement is pleaded at paragraph 42. And of course, as I say, that is closely linked. 42.1 states that the defendants have communicated the images generated by the software to the public in the United Kingdom. 42.2 states that 42.2 and 3 both refer to US copyright breaches. So on the face of it, 42.1 is the only allegation of infringement left. Now it refers to the images generated by the software, but interestingly, in the red text at the top of 42, it refers to including for the avoidance of doubt the source code. So this does lead to a degree of continued lack of clarity about what is the relevance of the source code in this case. But it does bear emphasis while we're on this paragraph. It's not suggested that, it wasn't suggested below, it's not suggested here, that there was any infringement by using the software. And as you will see...
Well, that depends what you mean by use, doesn't it?
Indeed, yes.
Because it refers to the images generated by the software, and how are images generated by the software other than by using the software?
Indeed, yes, my lord. I'm not suggesting that use is not part of the factual picture, but use per se, and indeed copying per se, are not the types of infringement they are relying on. They're relying on section 20. And that is...
well, you're undoubtedly correct to say there's no allegation of reproduction. But I'm not quite clear what you are saying about use. I mean, use is not a defined, restricted act. It's a common word which can mean different things in different contexts.
Indeed, yes, my lord. The point was simply the allegation of breach is that it was communication to the public, so a particular type of use by communicating to the public in the United Kingdom. So it was necessary for them to establish that the requirements of Section 20 were met.
But just, I'm sorry, I appreciate you're just getting going, and I apologise for asking a lot of questions about this, but I do think this is a point of some importance for other reasons that we will come to. Could we just go back to paragraph 40? Because that begins by saying, by letter dated 28th January 2016, Brown Jones identified at least 7 occasions on which SOM continued to use images generated by the software after termination of the license agreement on 25th January without the license, and then 2 examples are specifically pleaded, which occurred on the 27th of January. So would you accept that at that point we do have a complaint about use in the sense of the images generated by the software?
Indeed, yes. That was their allegation. That use, of course, is relevant insofar as it amounts to communication to the public.
Indeed, that's the only form of infringement of the UK copyright that's pleaded. Yes.
Indeed. I'm not suggesting there was no issue around use. There clearly was, although, as we'll go on to see, there was an admission of limited use. The use in principle was admitted.
Thank you.
And of course, those three heads, analysed according to those three heads of infringement, the US breaches were not pursued, and therefore the battleground level, insofar as there was a battleground subject to this admission debate, which of course I will come on to, was around communication to the public. And my lords and my lady will have picked up on what the learned judge said about communication to the public. He focused in particular on the question of whether UK audiences were targeted, and he found on the facts that there was no evidence that UK audiences were targeted, and therefore communication was not made out. And that's not subject to appeal, that finding on the facts. But in terms of the area of focus, as I say, we are looking at the risk and price charts today because that's what my learned friend seeks to emphasise. He doesn't seek to defend, of course, the judge's decision relating to the logo, but instead emphasises those risk and price charts. We will have a look at those a little later. I think what he means by the risk and price charts is the composite screenshots that we will look at in the bundle, which include a risk and price chart. And on my submission, that is actually, interestingly, quite a small subset of those generic categories of images. On any view, the learned judge did lack precision about identifying the works. That included, for example, that he erroneously included the logo, which is not defended on appeal. And I submit that is bound to create some problems when it comes to both making sure that the work's properly identified, but also analysing infringement in a clinical way. So with that in mind, I turn to the relevant law. Now, the broad overview of the law appears at paragraph 21 of my skeleton. That's tab 3, main skeleton, page 21. I set out 3 propositions here, and happily my learned friend largely agrees with this account, I think subject to the word detailed in the 3rd subparagraph, detailed evidence. So on these points at least we are agreed. But having said that, it is worth highlighting some of the key authorities. I don't propose to go through all of them, to see where my learned friend and I differ, at least in emphasis, on these principles. So if my lady and my lords have the authorities bundle, I propose to start with the Navitaire case. This is at tab 2, page 13. And my Lord Justice Arnold is, of course, familiar with this decision, but it concerned a deliberate effort by EasyJet to reverse engineer, in essence, a booking system that it had been using.
No, that's not right. They weren't reverse engineering the booking system. What they were doing were cloning the appearance of it.
Indeed, yes, my Lord.
The underlying way in which it worked was completely different.
Indeed, the code and the functions behind it were completely different. The appearance of it and the inputs and outputs appeared broadly the same to end users. I hope that's a fair understanding.
Yeah.
And so the introduction to this is given at paragraph 2 of the judgment. An overview. Page 23 of the authorities bundle. And Mr. Justice Pumphrey emphasises that it's both factually and technically complex. And he says, 5 lines down, what is alleged and not disputed is that EasyJet wanted a new system that was substantially indistinguishable from the OpenRes system, as EasyJet used it in respect of its user interface. And that term is used to denote the appearance that it presents to the user. And then his lordship says it substantially achieved this far from simple goal. So it was a successful, and I apologise if I created confusion by using the word reverse engineer, but it was a successful effort at creating a similar user experience, as it were, albeit with everything under the hood being different, and indeed no or limited access to what was under the hood of the original software. And at this point, it was a novel issue, both in terms of identifying the works and in terms of linking that to the analysis of infringement. And Mr. Justice Pumphrey notes at paragraph 5 a policy point about that. He says, there is an issue of general importance, because to emulate the action of a piece of software by the writing of other software that has no internal similarity to the first, but is designed to look the same and achieve the same results, is far from uncommon. If Navitaire are right in their most far-reaching submission, he says, much of such work may amount to infringement of copyright in the original program, even if the alleged infringer has no access to the source code and didn't investigate or decompile the executable program. So one gets a sense from this where Mr. Justice Pumphrey may well end up on some of the issues. If we turn straight to paragraph 125, and this is his key conclusions on this point. The allegation, it was expressed as non-textual copying, and it was expressed in terms of copying of business logic of software. And he says again, it's peculiar to computer programs, and he explains in essence that the problem is that computer programs can produce the same result using different underlying code. At 126, he cites Navitaire's case and the arguments that they've made with reference to the textbook. At paragraph 125, he then gives the memorable example of a chef who invents a new pudding. Writes down the recipe. The recipe is protected as a literary work, but the underlying way of making the pudding is not. And invention is an interesting word here, which it's possible Mr. Justice Pumphrey was using deliberately, because one spoken or unspoken feature of some of this case law is that the claimant is essentially trying to protect an invention, an underlying invention that they have worked on and that they consider as original. And indeed, there is a passage in Mazuma Games in the Court of Appeal, which we may come on to if we have time, where the Court of Appeal comments that some of the submissions sounded like they belonged in a patent case rather than a copyright case. And we will look at Mr. Mitchell's evidence in this case, and I will submit that much of that is actually quite similar in tone. It relates to his invention. And the courts must obviously be vigilant of attempts to protect inventions by the back door in circumstances where they don't actually amount to graphical works, or of course literary works. Sticking with this pudding example, Mr. Justice Pumphrey emphasises that the chef has put a lot of work into the pudding. And this, of course, leads into the idea, which is explained by reference to Lord Hoffman in the next paragraph, that putting in work is not always enough. So he cites Lord Hoffman in the Designers Guild case. Lord Hoffman refers to two propositions about the distinction between ideas and expression. The first is the concept that a copyright work may express certain ideas, so they are expressed, but they are not protected because they have no connection with the artistic nature of the work. And one example is a literary work that describes an invention, and the underlying invention, although it's been expressed, is not thereby protected. The second example he gives, or the second proposition he gives, is that certain ideas expressed by a copyright work may not be protected, because although they are ideas of a literary, dramatic, or artistic nature, they are not original, or they are so commonplace as not to form a substantial part of the work. Turning over the page, at 129, Mr. Justice Pumphrey concludes that the claim for non-textual copyright copying must fail because Navitare's program invites input in a manner that's excluded, it outputs its results in a form that is excluded, and it creates a record on a particular flight. And when the interface aspects are disregarded, all you have left is the business function. So he's carried out an exercise of distinguishing between the two. And I'll come on to the interface aspects very shortly. But that's his conclusion on non-textual copying. And at paragraph 130, he explains the policy reasons, in essence, why this is an attractive result.
Can you explain to me why you're taking us through this? Because I don't see it has any relevance at all to the issue with which we're concerned. Because this is all about the non-textual copying claim. And as you've just pointed out yourself, he's not here talking about the interface aspect. Not only that, when we come to protection of artistic works, an awful lot of water has flowed onto the bridge, juridically speaking, since the date of this decision.
My Lord, I highlight this passage because in 129 he makes a careful effort to disregard the interface. He separates them out. He identifies what aspects flow from the artistic element, the interface, and what aspects are purely functional. And that, I submit, is consistent with the later case law, in which the courts do encourage those aspects to be separated out. In terms of the graphical aspects, the artistic work aspects of this decision, the substantive part of the judgment is at 95 onwards, which I've cited in my skeleton, so it may be easier not to go to, but I do want to take the court to Annex 5 just to give an example of how this plays out in the real world. So starting at page 107. This is the detailed factual analysis that he includes of the graphical interface in this case. And one of the key examples he gives in the judgment is item 11. That's at the bottom of this page. And that's an example of what are known as the VT100 screens. And the court will see there is some effort to draw a box and have a title and position things and so on. But one can see why the court concluded that this was purely functional. There's another example at the top of the next page. And then in terms of the contrary example, page 110, unfortunately there's no screenshots of it. But from paragraph 309 onwards, Mr. Justice Pumphrey gives his analysis of what are known as the GUI screens. And he says those are rather different. At 311, he gives 310 to 311, he recounts the evidence on this topic. And then at 312, he draws a conclusion. He refers to the skill and labour that's gone in. First of all, there is the appearance of it, which he says is a graphic work. He refers to buttons with icons. Some of them are supplied from a library, from standard Microsoft icons, but also some of them are can be drawn. And in this case, Mr. Justin Wilde, who was the designer, drew them himself on a bitmap file. And the court reviewed them, 8 of them, there were 18 which he devised, and then their general positioning, the court says, is entirely conventional, so that's a conventional aspect. But the menu bar, he says, has to be designed, and then certain aspects of the positioning, he says, are a matter of taste, overleaf. So there is an effort at distinguishing aspects of this interface which are functional and aspects which are non-functional. And that's an example for the court of how that plays out in practice. I move on to Mazuma Games. And the emphasis in this case, at first instance, was on the first instance decision in Mazuma Games. The question of subsistence of copyright in the individual artistic works wasn't disputed on appeal. The appeal was about infringement. So this is tab 3, is Mr Justice Kitchen's decision in Mazuma Games, as he then was. This case, of course, concerned a variety of different pool games on computers and arcade games. And the court found that its designer had done 2 forms of creative work. These are set out at page 134, paragraph 101. So first of all, the designer, Mr. Jones, created the individual bitmap files, so effectively designing the individual icons and graphics in Microsoft Paint. And then secondly, 102, he built up composite frames using those bitmap files, so he overlaid them into particular patterns. And if we briefly turn to the annex to this judgment, we have some examples. Page 161, Annex A to the judgment. Internal page 425 of the report. So at the top we have an example of the claimant's software, and at the bottom we have an example of the defendant's software. And one can see
the graphical images produced thereby.
Indeed. This is the display of the user interface. So looking at the two, on the face of it, the court can see obvious differences between them. That partly goes to infringement, but it partly goes to the analysis of what exactly is protected. This is seen in the judgment. For example, at paragraph 1, from 138 onwards, the court looks at the different types of software, the different types of interface and how they appear. So at 139, he says the representation of the pool table in pocket money is quite realistic, even down to the black inserts in the pockets, the wide wooden edging and the metal corners. And in contrast, the trick shot pool table, which is the one at the bottom, is very cartoon-like, unrealistically wide cushions. So this is an aspect which, of course, is room for creative choice, the size of the cushions and so on. But there are other aspects. 140, he says, Belfruit, one of the defendants, was constrained to use a table in 2 dimensions by the graphics card. And once a games designer is constrained to 2 dimensions, a top-down plan of a pool table is the only real way you can do it. Again, at 145, he says that there is having the cue rotate around the cue ball on the screen is obvious, common, and functional. And at 146, he says that the evidence he heard was that this is commonplace and fundamental. So again, there is a distinction between the functional aspects and the ones which involve creative choice. And as I say, that is consistent with what one ultimately sees expressed in the EU case law. And I'm going to turn to that now to drill down exactly how it is expressed in the law today. So that's tab 5, the BSA case. And this was essentially an abstract reference about the scope of protection that is available in principle to graphical user interfaces. Looking first at the Advocate General's opinion, and this opinion was largely accepted by the court, adopted by the court for key conclusions. The relevant passage begins at 213 of the bundle, AG 70, paragraph number. So this comes after the court has considered protection under the directive and considered that the software itself, code, may well be protected, but the graphic user interface is not an expression of a computer program. But AG 70, he then says it nevertheless may be protected as a literary or artistic work. And then at AG 71, he repeats the own intellectual creation test. But at AG 75, he says the difficulty, as regards determining the originality of a graphical user interface, is the fact that the majority of the elements which comprise it have a functional purpose, since they are intended to facilitate the use of a computer program. Accordingly, the manner in which those elements are expressed can be only limited, since, as the Commission stated, the expression is dictated by the technical function which those elements fulfill. And then he gives the example of a mouse moving the cursor across the screen and so on. And at 76, he says, in those cases, the criterion of originality is not met, because the different methods of implementing an idea are so limited that the idea and the expression become dissociable. My learned friend says in his skeleton that the concept of functionality and the concept of dictated by technical requirements is solely about the distinction between ideas and expression. It is clear from this passage that it is not solely about that, it is also about originality. That,
and for that purpose, what he says at 77 is quite important. The National Court must ascertain whether by the choices of its author, by the combinations which he creates in the production of the graphic user interface, is an expression of the author's own intellectual creation, excluding elements dictated by technical function.
Indeed, my lord. So the National Court would have to identify the choices of the author, would have to identify the combinations that are created, and exclude what is dictated by technical function. So there are several different factors to weigh up and to identify quite carefully. And essentially this opinion is adopted by the court. One sees that at 221, paragraph 48 in particular, gives a similar formulation.
Sorry, can you give that reference again?
Paragraph 48 of the judgment, page 221 of the bundle.
Yeah, thank you.
Paragraph 48, the National Court must take into account arrangement, configuration of all the components, and in that regard the criterion cannot be met by components which are differentiated only by their technical function. And then at 49 it explicitly cites with approval points 75 and 76, which we've just looked at. It says that this goes to originality. There is reference at 50 to the author expressing his creativity in an original manner. And then at 51, the court sums this up in a response to be given to the National Court. My lady, my lords, the next case is SAS Institute. I don't propose to go to that in enormous detail. You will have seen what I say in my skeleton argument about it, and in particular, the passage where the court comments on the relationship between EU law and the traditional test on this. But I will briefly, on this point we've just been looking at, starting at page 246, make one comment. Sorry, page 249, paragraph 57. in particular, I am... Sorry. Yes, paragraph 57. At the bottom of this paragraph, and this is a discussion of the software side of things, but I do rely on the last sentence here, which refers to combinations and selections may well be choices of a kind, but they were choices of the wrong kind to be capable of protection by copyright. So this goes back to that point that it isn't necessarily enough, either in the software context or in the graphical work context, to say choices have been made. One needs to identify what sort of choice has been made and whether they are the right kind to be recognised under the case law. My lords and my lady, I now turn to the evidence and how these principles, I say, should have been applied on the facts of this case, and how I say they were wrongly applied. And I will focus on those risk and price charts. But obviously, before I do so, I do wish to emphasise again, these were not the sole focus of argument below. As I've said, the claimant's approach covered various different documents, debates on all kinds of fronts, including the source code. And in fact, there wasn't, apart from the passage we will look at, there wasn't a step-by-step analysis of these risk and price charts. And before we go any further, it's probably useful for us to extract the relevant screenshots from the bundle, or you can keep it in a tab or on one finger. I like to take them out. They're at tab 5, page 109 to 111. I think are the key ones.
One 109 to 111.
109 to 111.
Mm-hmm.
Start with the evidence in chief. That's tab 3, Mr Mitchell's witness statement. Starting at page SP 25, but there's also a 326 page number on it. And there's also a page 19 of 25 page number on it.
Sorry, could you give me the page number again?
SP 25.
Thank you.
That's the main one.
Yes.
So essentially the only evidence in chief on this design, on the design of these screenshots or indeed any other parts of the interface is 116 to 118. 116 refers to the software performing thousands of calculations, and that's what happens, he says, in a video game, and then you generate images. 117, he says, the one software similarly performs thousands of calculations to determine asset prices, profit and loss, adjustments, margins, volatility, and so on. That aspect is clearly a function of the software and its functionality. These are the formulas. They may well be formulas that took him a lot of work to come up with, but they are aspects of the functionality, how you translate an input into an output. Analogous in some ways to the input and output relationship in Navitaire, but of course much more sophisticated because they relate to financial calculations. At 118, he states, these calculations result in generating an image or series of images as market data changes, which we can interpret as a form of video. Now, this passage seems to be referring, when it says an image, to the graph itself, to putting a line on a chart. Similar to the game, the user doesn't enter the raw data. The raw data is market data here, or perform the calculations. These two sentences, as I say, appear to be talking about how you put in the market data and you get a chart or a graph that shows you what an options trading strategy.
Talking about the entire image, isn't it?
The third sentence, he then refers to the entire image. and he refers to everything. He refers to line types, colours, transparency, layouts, font types, etc. And he says that was designed by me as the developer. Now, as the court will see on cross-examination, he backs down from some of those claims. For example, the underlying components he accepts were taken from a library. So as it was at the close of trial, the argument relates to composition rather than in designing individual elements. So that's the evidence in chief. The judge described it as rather limited. Moylan friend describes it as scant in his skeleton. And I would submit that on the face of this, it's not enough, and indeed the learned judge didn't rely on it. So we have to look at what emerged in oral evidence, which is principally what the judge relied on. The transcripts at tab 4, and it starts at SB 71, the relevant passage. Right in the bottom hand corner, page 294, line 20, Mr. Mitchell is taken to 2172. Now that handily is the first of these pages we have to one side. So Mr. Mitchell is taken to that, and overleaf he accepts he's familiar with this. At the bottom of page 295, at the top of page 296, he's asked whether the features are run-of-the-mill, ordinary, and bland, and that's not made as a aesthetic criticism. And of course, Moylan friend makes a great deal of saying artistic merit is irrelevant, and of course I fully accept that. The question is choices.
Yes, but when you look at the question, bridging the pages, your case is that the look of the software is distinctive. One understands from that this question is about the passing off claim. It's not about the copyright claim.
Indeed, these questions were principally about passing off. They were drawn upon by the judge to make his findings on copyright.
Well, this passage is about passing off. The next one, 299, is about copyright.
Yes. They lead into each other, so I did want to highlight a few points from this. He emphasises the combination of the option chain and the risk chart in the middle of this page, line 12, and he says that was not available prior to my development. And then his answer at the bottom of this page, line 22, he makes the same point. He says, the risk chart is the bit on the right, and the option chain is the bit on the left. And if one looks closely at these images, one can see those headings, option chain on the left, risk profile on the right, on the screenshot. Unfortunately, the resolution could be better. But I hope it's clear that there is a table of numbers on one side and a space for a graph on the other. So what he says is his innovation, as it were, was having them combined together so that you type in the numbers on one side and it instantly performs the calculations and populates the graph. And so that is the run into the evidence that relates to copyright, which, as my lord says, comes into page 299. And this is actually a question from the trial judge that initiates this. He says, you've been saying this is all very distinctive, but hang on, did you build in any way on Microsoft? And Mr. Mitchell accepts this. He goes on to accept essentially that he used various libraries to build all these components, so the buttons, the images on the buttons, and so on, the ribbons. But he says that's the library doing what it's wanted to do behind the scenes, but the look and feel of it is my brainchild. That's an expression which the learned judge quotes. Going on to page 300, line 6, he says some of them weren't from Microsoft, they were from a third-party library called Dev Express. And then the key passage is 19, line 19 of page 300. He says, everything is original because I designed how the ribbon looks, what goes into each component of the ribbon. That appears to be a reference to what are the different headings, what are the different features on the ribbon that you can click on. What name you call it, what buttons, and how you make the buttons work, how they work when you hover over it. Everything there is my design, and he compares himself to a painter using a brush and says he extracts something into various locations and gives them functionality.
Now, would you accept that nowhere in that passage is it put to the witness that the images produced are dictated by technical function?
My lord, not in terms, no. He obviously gives the evidence that he gives. The trial judge was in a position to draw whatever inferences he could draw from those questions. My case is there was no evidence in there that the images were not dictated by technical function, and that these ribbons involved creative choices on his part.
But that's exactly what the answer at paragraph at line 19 to 25 is saying, isn't it? He says everything is original because he's designed it. He says it's like a painter using paint and brush. So that's exactly what he's saying.
Well, my lord, a witness comparing himself to a painter doesn't, with respect, make him a creator of an artistic work. He has to say what choices he made and how he made them, so that the court is in a position to carry out that assessment. In my submission, this is simply not enough to meet the test in the case law that we've looked at, especially because it comes in the context where he's asked what's distinctive about the software, and he says what's distinctive is you have a table of options on the left and a chart on the right, and one side instantly populates another. That's what he's proud of. That's what his evidence is, that the key choice that he made. And that key choice obviously is not permissible. It's simply a function. He doesn't even go so far as to say, well, I weighed up whether to put the chart on the right or the left and decided that it was more user-friendly to put the chart on the right. There's simply no evidence of a choice like that. His evidence is he came up with this idea, he came up with the calculations and the code for it. He pulled in some images from a third-party library and placed them on a screen. There's nothing from which the court could infer or conclude that the placement of those images on the screen involves a personal touch from Mr. Mitchell, involves an element of the kind of artistic skill and labour or the kind of artistic originality that is needed to make something an artistic work.
And so in relation to what's being said from line 19 on page 300 at SB 73, you say that's all about functionality rather than appearance?
My lady, yes, it's about functionality and it's about elements of the appearance which flow necessarily from
the functionality,
which don't involve creative choices. And it is a positive test. It is something that the claimant, someone who seeks copyright protection, has to show. It's not a defence. It's something that the claimant actively has to show that they have made original choices. And that, to some extent, I think it would be my answer to my lord's point about it wasn't put to him in terms, you have not made creative choices. That's something which the court has to assess on the evidence that he has put forward. With that in mind, and having looked at that passage, it might be a convenient time to put that screenshot back at the back of tab 5. would like to return to the judgment in the core bundle. See how the learned judge deals with this. And of course, as I say, that's in the context of many, many other points about originality and so on. Core bundle tab 5, tab 6, page 111. CB 111.
Yes.
So paragraph 212, and this is after, of course, discussing the software and the source code and so on. But at 212, he says, in relation to subpoint 2, and that's the images generated by the software as graphic works. Graphic user interface as a graphic work. He notes the defendants agree that in principle, individual frames can be graphic works, artistic works. However, they submitted that interfaces do not qualify automatically. They only qualify if they would otherwise meet the requirements for copyright protection as an artistic work. And that is a point which I emphasise on appeal, and I say he did correctly identify. My learned friend in his skeleton argument comes close to saying that Navitaire decided once and for all that graphic user interfaces are artistic works, and therefore one doesn't need to hear evidence in anywhere near the same level of detail on that. And I disagree. I suggest that that's contrary to what the authorities we've looked at have made clear. 217, he quotes from the first instance decision in Mazuma Games, passage we've looked at. And at 214 is his analysis. He notes that the evidence as to the creation of the interface was rather limited. And he says, at trial, he refers to the passage we've looked at, his evidence was that he'd obtained the components from a third-party library, but he was responsible for, quote, the overall look and feel. And the trial judge said he was satisfied that that work of creating the look and functionality of the interface, including arrangements of the tables and graphs, did involve the exercise of sufficient skill and labour for the result to amount to an artistic work. The analogy to the GUI screens in Navitaire is apposite, he says. So, focusing on 214.
Well, just before you do that, what do you say about 215? And maybe you're coming to this, in which case that's fine. But one mustn't overlook what he says in 215, particularly in the last sentence.
Yes. So 215, the third subpoint is actually an additional level of, it's the screenshots of software in use, but essentially it's a similar thing. Because a point that was taken at first instance on these screenshots was that it was a combination of user input and the software. And actually the main input onto these screenshots was the user's work.
But he rejects that argument.
Yes,
he says
indeed.
the image in each case is predominantly the result of the computer algorithms with by Mr. Mitchell.
Indeed, yes, and we don't challenge that.
And the reason for the interest of the last sentence is there's a difference in phraseology. Because in 214, he quotes the witness's reference to overall look and feel. He then says look and functionality, and one wonders if that might have been a typo or other error, because when he then comes back to it at the end of 215, he says the overall look, framing and layout of the graphics and tables. So certainly at that point, he's not referring to functionality.
Yes, there is a distinction, but it is clear in my mind he does refer to functionality in 214, and this is what I say is one of the problems with this, that it does seem that he took it into account. He certainly doesn't direct himself not to take functionality into account, as one would expect. And on the face of it, if he had given that direction to himself and said, I acknowledge these parts of the case law and these parts of the rules I have to apply, one might be willing to give him credit and say it may well be that he misspoke, it may well be a typo. But on the face of it, this passage talks about the look and functionality. It talks about the arrangements of the graphs. It talks about the look and feel of the display. It doesn't involve excising elements of that look, which flow necessarily from functionality, which flow from the fact you have a table on one side and a graph on the other, the fact that you have to have certain elements of options trading strategies in there. He simply didn't. And in my submission, if he had, there would be very little, if anything, left of these user interfaces. He does expressly rely on functionality. And I say that, combined with the fact he doesn't direct himself to the key principles, does suggest he wasn't grasping the nature of the test. My learned friend suggests in his skeleton that he wasn't referred to the BSA case. Incidentally, that wasn't right. The BSA case was cited in our case.
It was cited on the other limb of the argument. It was cited in relation to the claim in the software as a literary work. So when one looks at the closing submissions, the relevant extract from BSA that's set out is all about the claim to under the software directive. The bit that's relevant for our purposes is not cited.
Indeed, yes, my lord, but they are linked in the sense that once one identifies what isn't protected under the software directive, one can't use the artistic works as a backdoor for circumventing that. And that is one reason why...
Well, one's got to be very careful with that proposition, because the part of the difficulty in this area is that the Court of Justice, and they will use Latin, so I'm only repeating their Latin, they say that the software directive is a lex specialis as against the Infosoc directive, which is lex generalis in this regard. So the fact that you can't claim protection under the lex specialis doesn't exclude the claim for protection under the lex generalis. That's the basic approach. And that's one of the propositions you get out of BSA, but one gets it from other case law as well.
Indeed, yes. The point I was seeking to make is that one has to look at creative choices, and there is a category of creative choices which are not good enough, as it were, in the framework laid down by the Court of Justice.
Well, absolutely right, and that's the core point, isn't it? Is your case, which I perfectly well understand, is that the case law says that there's got to be free and creative choices, personal stamp, and so on and so forth, and you say there isn't any.
Indeed, my lord.
Yeah.
Indeed. And not only is that not made out on the evidence before him, but he didn't focus on the correct test. It's notable that he doesn't identify particular screens. I come back to this point. He sticks instead to generic conclusions about the software as a whole. And the court will recall by comparison that domestic cases, Navitaire and Mazuma and so on, do involve a detailed frame-by-frame analysis of what particular choices were made. This is not just a question of judicial evaluation for the trial judge to decide how much evaluation needs to be done on the particular circumstances of the case, because one has to identify the protected work with particularity. And instead, the trial judge, with respect to him, has made a generic declaration which wasn't founded on the case law. My lady and my lords, I submit that screenshots like this, if they are protected as artistic works, based on the evidence that was heard, it would drive a coach and horses through the policy of the current law, because almost any software could be given an interface like this and then protected by copyright through the back door by characterizing it as an artistic work. On that basis, therefore, on a proper application of the law, I submit the learned trial judge was wrong, and I would respectfully ask the court to allow the appeal.
So, just for my purposes, what you're saying is, in order properly to apply the test, you have to deconstruct the image that is being claimed to be copyrighted and identify which elements are functional, which elements involve artistic choice.
My lord, yes. And on this case, of course, Mr Mitchell or Mr Mitchell's entities were the claimants. So the
Yes.
onus was on them to do that.
So two things. One is the judge didn't do that, and the second is the evidence wasn't there to enable him to do it. You see what I mean?
Correct. Yes, he didn't apply the correct test, and if he had, he wouldn't have reached that conclusion.
Yes.
Unless my lady and my lords have any further questions on the appeal, I propose to move on to the cross appeal.
No, thank you.
So my submissions on the cross appeal, I'm going to address under three categories. First, I'm going to look at the alleged admissions themselves. Second, I'm going to look at conduct and events between October 2021 and May 2023, how the case developed. And third, I'm going to look at the learned judge's decision in May 2023 and how he approached it. But before I turn to the first of those points, I do want to highlight one point which I've already flagged, which is the fact that the cross-appellant is asking the court to overturn a finding of fact made at trial, that there was no infringement, that there was no communication to the public. That was debated at trial between the parties. The learned judge applied the principles in Warner against Tunin relating to targeting, and that decision is not challenged on the merits. What is challenged is this decision about admissions. So on the basis of the learned judge's findings, the admissions, would I suggest they would be fictitious ones because there was no infringement and there is no challenge to the finding that there was no infringement. If the claimants succeed on that cross appeal, the judgment on the facts after trial would be reversed by 180 degrees. And I submit that is, it would also mean, of course, that my clients would not have the chance to apply to withdraw the admissions. That's the point I'll come on to. But that is a decision which I suggest this court should pause very carefully before making. Starting with the alleged admissions, there are three main places the admission is said to have been made. One is in Miss Daniels' witness statement, one is in pleadings, and one is by conduct. I'm going to take the pleadings first because they come first chronologically, although they were revised and reserved a number of times. If we go to tab 9 of the core bundle, page 157, this is my client's defence. It may be useful to note down the dates of the different amendments. The red amendment, the amended defence, was the 15th of December 2020. Green amendments, the second set of amendments, are the 10th of November 2021. And the blue amendments, the third set of amendments, are the 9th of May 2022. This document's been reserved a number of times at different stages through the litigation, which was long running. And that includes various amendments to the pleading on infringement. That's contained from CB 181 onwards. we've already looked at the relevant passages of the POC. One sees initially there was a refusal to plead in defence because of alleged inadequate particulars. And then the red amendments, the first set of amendments, start to go into detail. The blue amendments obviously expand on that. Those were the amendments that came close to the trial. What the red amendments say at 51A.
Well, before we get into that,
Yeah.
surely we need to start at paragraph 49.
Yes.
Because paragraph 49 pleads two positive cases. In the red, we have a positive case pleaded that there's no copyright
Yes.
because there's no intellectual creation.
Yes.
And then in the alternative, in the blue amendments, we've got the assertion that if there is copyright, the owners are not the claimants but the defendants.
Indeed.
So a positive case on first subsistence, secondly ownership.
Indeed, yes. That was there from an early stage. That's the pleading on subsistence and ownership and authorship. Then 51A deals with the parts of the POC that deal with infringement. The principal red text, skipping about halfway down, it is denied if it is alleged that Mr Sheridan used the software to generate images after expulsion. So it was admitted that he generated them, but he denied that they were generated after expulsion. And he says the images that have been given in the examples were generated before expulsion.
And we now know that actually that's incorrect.
Indeed, my lord. And that was one of the things that was discussed at trial. And indeed it's added in the blue amendments. So that was a concession in the blue amendments. I think it was one reason why the blue amendments were made. So at the bottom of the page, there is more text about these January 16 videos, and then overleaf. It notes the rest. This is the passage that the cross appellants rely on. The reservations of rights are noted. So this is a reference to we reserve the right to plead more following disclosure. The defendant's position is that the question of whether or not copyright subsists is a matter for the trial on liability and can be determined on the basis of pleaded examples. So that's effectively saying there are enough examples for the court to make a determination on subsistence. The question of the extent of use is a matter for the trial on quantum, and if liability is found, the defendants will provide disclosure of such use.
So would you accept that the positive defence to infringement that is put forward in 51A is licence? Because the case that's put forward is the only use was prior to expulsion, and therefore it was licensed use, and therefore it was non-infringing.
Indeed, yes.
But there is no defence put forward that if it was not licensed use because if it was after expulsion, there was no infringement for some other reason.
My lord, no, and I will come on to essentially my submission on that is that in particular focusing on the targeting point, this was the point that the defendants ran at trial and there was no pleading point taken against them on it.
But you would accept that there's no positive case pleaded, that there's no targeting?
It's not pleaded, no. But on one view, it falls within the final sentence of 51B in particular. There's a generic denial of infringement of copyright. And of course, that refers in particular to the circumstances where it's denied that the images are capable of copyright protection. The text after the comma, it is a generic denial.
Yes, but the basis for the denial is the three we've seen. Firstly, no copyright. Secondly, even if there is copyright, you don't own it. We do. Thirdly, in any event, even if there's copyright and you own it, the use you complain of is licensed. So those are the three bases for the denial of liability. There's no independent basis saying, and fourthly, even if you own it, and even if it subsists, and even if it's not licensed use, nevertheless there's no infringement because there's no targeting.
Indeed, as I say, that's not in there, and I'm not going to try and dig it up in there.
Very good, thank you.
But I do say that this is precisely the kind of point that could have been taken and should have been taken at trial, even after receipt of our written closing submissions. It would have been very easy for the claimants to say paragraphs X to Y of their closing submissions are not pleaded, and it's far too late for them to raise it. That wasn't a point that was taken, and that is how pleading points can and should be raised. It is usually too late to wait and try to raise them way after the event, or even in the case of the CPR 16.5 point about non-admission, a denial with no reasons given, that's taken on appeal for the first time. And that's not the way pleading points in my submission, on my case, should be taken. Because, of course, if you take it at first instance, that gives the other side the chance to ask indulgence to amend it. And then it's for the trial judge to decide whether that's good enough or whether it's all come too late. So at worst, I suggest this pleading is ambiguous. And that's a point borne out by the way the claimants responded to it. As the trial judge noted, in their reply, they say it's impossible to understand. And indeed, following service of the red text, which was December 2020, they write to us on numerous occasions saying, we're not clear whether you've made an admission or not. And that's contained in the material we're about to look at, which is in the supplemental bundle. Because that leads us on to Miss Daniel's witness statement, which is the second alleged admission. Before we turn to this context, I do want to give a note of caution, which is the court will have picked up that there were a significant number of skirmishes between the parties right from the start, almost constant. From October 2021, they were all reserved to the trial judge. That was over a year in which he was continually adjourning the PTR. There were 4 PTRs in this case, and I think 8 or 9 formal applications in that period. Vast amounts of money was spent on it. Those disputes included disputes about the scope of disclosure. One of the outcomes of that was that my clients provided all videos after termination, were ordered to do so and did. One of the outcomes of those disputes was that disclosure was ordered according to the list of issues, broadly the list of issues that the court has seen, and we'll come on to that. But I want to say this before we look at Ms. Daniel's witness statement, because I use the term archaeology in my skeleton argument. And this is a case where one is looking through very old procedural events that took place significantly before trial, digging through them to try to find something which can be used. And the court does need to be careful, especially on appeal, bearing in mind that my lady and my lords haven't seen all of the events that take place, and indeed I'm not aware of all the events that take place because I was instructed after many of these procedural skirmishes. That's one reason why, for all concerned, especially the trial judge, the list of issues assumed great importance. We'll come on to that. So starting at tab starting at tab 24 of the supplemental bundle. I'm not going to go through this tab, but in summary, it is a series of chases in early 2021 from claimants solicitors at the time, essentially saying you've made an oral admission in a phone call, and we'd like you to confirm it in writing because this is what we think has been admitted, but we're not sure. And we want it confirmed. And there's numerous chases which are not responded to. The closest thing there is to a response to that is the Daniels witness statement at tab 25. That comes in June 2021. And the court will see that there was a context of disagreement on pretty much every aspect of disclosure. At paragraph 10 of Miss Daniels' witness statement, she refers to 3 core issues that remain to be determined as she understands it. They are disclosure in respect of passing off, disclosure in respect of copyright, and disclosure in respect of the partnership agreement. So there's 3 issues she considers alive, factual issues. And then at paragraph 14, she says there's a dispute between the parties over whether these post-2016 videos are relevant. And she gives the difference between them is about 6,000 files. And she says that reviewing the latter would be disproportionate.
No, she says in either case.
Sorry?
In either
In either case, yes, and there are proposals made to sample them, essentially. So that's the position being put forward for this particular CMC. My clients are proposing to sample them. Paragraph 15, she refers to this meeting, and she says that the Defendants Counsel confirmed the defendants accept they have made limited use of the images of risk and price graphs. So that's the best evidence the court has on this oral admission.
Well,
And that's
you need to go on in presentations that were either produced after their licence were revoked or were produced prior to its revocation but made available to their customers after that date.
indeed.
So that is an admission flat contrary to the pleaded defence of licence use.
After their license. I'd have to compare that to what the pleading states.
Well, we've just seen it, that the pleaded defence, as we've just been through, was first no copyright, secondly you don't own, thirdly the use complained of is licensed because it's before revocation. This is an admission that the use is after revocation and therefore not licensed.
My lord, the primary case in the defence was the licence wasn't validly revoked. So it was purportedly revoked, a revocation notice was sent, but there were no contractual grounds for revoking it. So my reading of this, I mean, it's not a central point for our purposes, but my reading of this passage is this is a reference in sort of plain English terms to revoke it. It's after the notice was served. But the pleaded case was there was no valid revocation. That was obviously determined against the defendants at trial.
And then she goes on to say the defendants don't accept the images of copyright works, so that's the first point, no copyright. If they are found to be copyrights, their primary position is the author is the users of the software, not Mr. Mitchell. So that's the second defence, you don't own. And then she says this is set out in the amended offence. So she's quite clearly saying, and if there was any doubt about it, it's confirmed in paragraph 16, isn't it, where she says in the second sentence, any video produced after January 2016 that contain a risk price chart originating the auction net cipher will amount to an infringement. So she's plainly saying, is she not, we contest subsistence, we contest ownership, but if we fail on those two, we're not contesting infringement.
Yes, that's what 16 says, and that in my submission is it's not an admission, it's a position being put forward at a CMC to try and broker a compromise on disclosure. And it's in the context, both before and after, of numerous discussions, very extensive discussions and arguments about what the disclosure should be. And it's ultimately a proposal which wasn't adopted. In October 2021, disclosure was ordered by reference essentially to the list of issues that we will look at, Model D disclosure on all of the list of issues. And that includes the question of the extent and nature of the post-2016 use. So that is the highest point, I think of the case on admission. This paragraph 15 and 16. June 2021. There was also a skeleton argument served at the same time. That's at tab 27, paragraph 32. 33. This is slightly different wording. It refers to concession of use, but not concession of infringement. Then it says any use will amount to an infringement if they can, quoting what Daniels 2 says. So in my submission, it doesn't add to that, it simply repeats what Daniels says. But again, it's a position being put forward at a contested disclosure hearing relating to many, many videos, and there were many, many disclosure hearings after that, which, unless the court has any questions on these topics, I propose to come on to now. So, in terms of the conduct after this hearing, the conduct of the case after June 2021, as I've said, there were many, many applications. The trial judge reserved this case to himself from the 18th of October 2021 onwards. And he refers in his judgment to a PTR before him where he saw that the case wasn't ready for trial at that stage. And as I say, there were unfortunately, three more PTRs that we had to go through. This is a case, I submit, where one has to give even more weight than usual to the experience of the trial judge in managing the procedure and in understanding how the case has evolved. By the time of the trial, he had been involved in the case for longer, I think, than any of the lawyers involved. I may be open to correction, at least for most of them. And he had presided over skirmishes on pretty much every topic imaginable, including disclosure, and including on the topic of the post-2016 videos. So I do submit that that is a reason for giving weight to his views. My learned friend seeks to argue in his skeleton that the case was run on the footing that admissions had been made and that everyone proceeded on that basis. And I do respectfully disagree, and that was known to the learned judge at trial. And I highlight 5 steps of the procedure where it's clear that that wasn't the case. The first is pleadings. Parties after June 2021 served, in the defendant's case, 2 rounds, in the claimant's case, 3 rounds of amended pleadings. The claimants in their amended pleadings didn't seek to rely positively on any admissions. It didn't say infringement has been admitted. That's the end of it. Instead, they continued putting forward a positive case of infringement on the facts. And that is a clear sign, I would suggest, that nobody believed there was a binding, irrevocable admission from June 2021 onwards. The second aspect of the procedure that's relevant is the evidence that was served for trial. And if I could take the court back to Mr. Mitchell's trial witness statement. In fact, there were, I think, a dozen different witness statements served by Mr. Mitchell, but this was the principal one which he relied on.
Sorry, can you give me the tab number?
Yes, tab 3 of the core bundle.
Thank you.
Sorry, the supplemental bundle.
Okay.
Supplemental 3, page 7. This document was served in October 2021, so after Ms. Daniels' alleged admission, after the events of that CMC in June 2021. and this is evidence he continued to rely on at trial. We've already looked at it briefly in relation to the creation of the software from the interface. But what is interesting about this is that in October 2021, he actively sought to show that there had been an infringement on the facts. If the court looks at paragraph 116 onwards, SB 25, we've looked at the first three paragraphs here, 116, 117, 118. Then turning over, at 120 and 121 and 122, he talks about searches he's done, essentially using his back-end version of the software to identify who's been accessing it and who has been logging in. So he's tracking activity. And I believe these logs were included in the trial bundle, but he certainly refers to having done these logs. At 124, he refers to the fateful 51B that we've looked at, that his solicitor said were impossible to understand. And this is where we get the contradiction. In fact, he created videos on the 26th and 27th. That was what led effectively to the blue text eventually being added, making that concession. Around August 2016, I noticed that Mr Sheridan had re-recorded various videos on YouTube. And so he notices that, and at 126, he refers to debates with the defendant's solicitors. He concluded at 127 that defendants had removed the public-facing videos to deceive him, but kept videos unlisted in YouTube and continued to sell them in the knowledge he would not be able to see them. And then at 128, he refers to the money being generated. And then at 130, he contradicts what the solicitors have said. Now, this is all under the heading of breaches of copyright post-expulsion, post-termination. And indeed, documents relating to this, lists of post-2016 videos, very lengthy ones, were included in the trial bundle to make that point good. So these points were in disclosure, and they were in evidence, in the claimant's own evidence. There's no suggestion in this passage that Mr Mitchell wishes to rely on any sort of admission. The third aspect of this procedural conduct is the agreed list of issues, agreement of a list of issues. And I should give a correction. I suggested in my skeleton this was drafted by the claimants. In fact, I'm told that it was drafted by the defendants in the first instance, but agreed. So it was originally drawn up in 2021. And as I say, in October 2021, Model D disclosure was ordered by reference to that list of issues. Substantially, not entirely, but substantially for present purposes in the form that is before the court today. Including the issues which I'm going to take the court to. The list of issues, sorry, it is in the supplemental bundle. And it's supplemental bundle tab 2. It also appears at the back of the judgment, but I think it's useful to see tab 2 of the supplemental bundle. Tab 2 of mine, but tab 1 of my learned friends. So if there is a difference, I'm looking at page 6, which is the covering email. This is where it's Monday the 14th of November, which is actually day 3 of the trial. There had been some industry over the weekend. And he says, please find attached the final approved version of the list of issues. He makes comments on an issue that's not relevant for the present purposes. And he says he expects the parties' closings to address these issues in the order they appear in the list, either in the body or as an appendix. And then he gives further directions. The approved list of issues is then at tab 1. There's no dispute that this was agreed by the claimant's representatives, and indeed it was substantially unchanged. There were changes, but it was substantially unchanged in relation to what we're looking at in the 13 months or so before the trial. And at no point did the claimants object to it. The key issues are 24 onwards. So 24 and 25 obviously will be familiar to the court, and they're the ones that my Lord Justice Arnold has noted were front and centre of the case that we presented in our pleadings. 26. If Mr Mitchell is the author of such works, have they been infringed by Mr Sheridan and or SOM by the use of images generated in the software in A, the 27th of January YouTube presentation, or B, the 27th of January earnings class? 27. Have they made any use of the software since expulsion? And in particular, did they use the software after expulsion to generate the images referred to at 26 above? 29. If so, this point remained pleaded, remained run at trial. Have they infringed the literary copyright existing in the source code? So those are 2 subsistence and authorship issues and 4 infringement-related issues, as it were. And even on day 3 of the trial, the claimants agreed to them. That's not just a trivial point. It was clearly important to the trial judge to have the list of issues well defined. It's important to any trial judge to have that well defined, possibly all the more so when the pleadings on both sides leave something to be desired. It helps the judge to identify what the real dispute is about and what both parties are expected to address in their factual evidence. No explanation has been given by the claimants for why they agreed to this list of issues, other than that it was an error, that it was an oversight. The 4th element of this landscape I want to take the court to is the written submissions at trial, or rather, I think it sounds like the court has already looked at those. The point is a simple one, and I don't think it's disputed. The claimants.
The first point is there was no skeleton argument from your side in breach of the rules. What's the explanation for that?
There was an issue around an application to adjourn trial. As I understand it, my clients were not. I wasn't even instructed at that point, my lord. My understanding was my clients were not ready for trial, and they had expected the trial would be adjourned. There was a dispute around late disclosure of certain materials, and my client's position was it would be unfair for us to have to go to trial having had this late disclosure. They were distracted by that application, and that's why they were unable to do a skeleton. They prepared an opening note, as it were, a short document, but that's absolutely correct. There was no skeleton.
Sorry to interrupt, my lord, but just while my learned friend mentions it, for convenience, it might be worth turning to that opening note, and in particular what is said at paragraph 12 of my learned friend's opening note. Page 126 of the supplementary bundle.
Yes, sorry, this opening note was by Mr Grieger, who sits behind me. The court may have picked up that at the outset of the trial, counsel weren't instructed. By day 3 of the trial, counsel were instructed. It was a messy trial. So yes, this opening note states what it states. The claimants obviously did do a skeleton argument in advance of the trial. It was, I think, may have been slightly, yes, there we go, 7th of November, it's the previous tab. That skeleton argument addresses breach of copyright in the final paragraph. The defendant's breach of copyright should be the subject of an inquiry. That's all that's said.
Yeah, and what one sees is they address subsistence and ownership, which are the pleaded issues, and they note that it's accepted that use of the software generates risk and price charts, and that's the basis of the claim for copyright on behalf of the defendants. And there's no sign there that counsel for the claimants thinks that there's any separate issue on infringement. He thinks that the issues he has to address are 1, subsistence, and 2, ownership.
My lord, it's a skeleton argument in the traditional sense in some ways. It doesn't go into, it's a 10-page document. If one compares that to the length of the closings, there's a drastic difference. And if the court looks through other sections of this skeleton, no criticism at all to Mr. Turner, it's a very strong document. But it is very much a traditional skeleton in the sense that it doesn't have line-by-line opening submissions. Certain points are addressed in more detail than others, and of course, those issues which my lord has mentioned were front and centre of the case right up till trial and even after trial. The emphasis on targeting did come in the course of the trial, I fully accept that. Having said that, Mr. Eaton Turner had agreed, signed off on the list of issues. So if there was one solid point which counsel for both sides could be expected to look to as a set of issues that would be addressed and debated at trial, it was the list of issues for trial, which was approved by the court. And I should say that those issues on copyright infringement, the 4 that we've looked at, there was no suggestion from me to Mr. Eaton Turner that they shouldn't go in, or that they should be modified in some way, as I understand it. So that's the position at the start of the trial. We then have a written closing from the claimants. We have a written closing from the defendants. And we have reply closing submissions from claimants. The point about targeting is first developed in closing submissions from the defendants. And there is a great deal of analysis on it. The claimant's reply, it's a much longer document. It runs to some 32 pages. And it addresses some of the points raised in the defendant's closing in more detail again than others. But the claimant's counsel has had every opportunity to consider the points in the defendant's closing. He's been directed by the court, if possible, to structure his closing by reference to the agreed and approved list of issues.
What do you say about paragraph 2 and 3 of the claimant's reply submission?
Yes, so, and this...
Defendant's closing goes beyond and differs from the defendant's pleaded case.
Yes, indeed. In particular, in advancing a case of unfairness, in the claimant supposedly not giving the defendants warning of breaches of contract and the opportunity to remedy them. So this was part of the partnership dispute. There was a substantial argument developed in the defendant's closing, which the trial judge rejected, that the expulsion was done in a procedurally unfair manner, contrary to a duty, an express duty of utmost good faith in the partnership agreement. That was developed at great length in the defendant's closing. The claimant answered it on the merits, but also objected to it in principle. So that objection, it's clear what there is reference to. Paragraph 4, there is also a clarification of the defendant's position. So this introductory section actually is illustrative because it's the defendant's chance to lay down markers about the points they object to, points of the pleadings they think have been misunderstood, the aspects of the list of issues that they think need to be addressed in more detail or shouldn't be addressed. And again, there's no suggestion at all either that the final 4 issues of the list of issues should go out the window and shouldn't be determined on the basis of an admission. I don't think the word admission was mentioned anywhere in these various submissions. There's also no suggestion that the defendants have acted improperly in raising these points. And of course, a party who thinks that a point like this has been wrongly raised, it is incumbent on them and their legal representatives to say so, not just to nod it through.
Yes, I mean, you're right to take that point, but it's very odd, isn't it? Because when you read what's said about copyright, again, Mr. Eden Turner deals with the 2 issues that are pleaded. He deals with subsistence, he deals with ownership. He says not a word about infringement as a separate issue.
Well,
and you're right, he makes no objection to say, hold on a minute, I've been ambushed by an argument on targeting which has come out for the first time in the defendant's written closing submissions. So I take your point, there's a complete absence of a process that one might have expected. But what do you say about the fact that what he's actually doing is addressing the pleaded issue?
there is no protest, there's no positive case on these new points. The closest there is to it is paragraph 152. And again, in some ways, this is again, to be commended for precision, it's trying to keep this document, which is necessarily a long one, as short as it can be. So 152, he simply says, have a look at our pleaded case, have a look at our particular claim, where this is our pleaded case on infringement. At 153, he notes that there's a new point being raised by the defendants, and that is a new way in which the case on artistic works, that point has been put. And he analyses.
But you have pleaded.
I
mean, those are the red amendments,
yeah,
which clearly take the point it's not an intellectual creation.
Yes.
So you had pleaded that.
Yes. I mean, the point is he has the chance to be alive to the way in which the case is changing. He has the chance to put up objections about what's not pleaded, and he doesn't. And the direction we've looked at, my lord, from the trial judge says, I would like you to address the approved list of issues in your closing, which you have agreed, subject to my approval. So he's entitled to structure his closing submissions in any way he wants. But if he misses points which have been argued and which are flagged in the list of issues, he can hardly blame anyone else for doing that. One doesn't just give closing submissions to the points you would have liked to have been made against you. You have to engage.
Yeah.
So that is the written submissions. That was, I think, the fourth of 5 conduct points I was going to make. The fifth feature is what happened after the trial. And I can go through that relatively briefly, especially if the court now has that additional chronology, which we placed at the back of core bundle, at the back of the original chronology, which is tab 4 core bundle. So, and as the court looks at this chronology, many of these are, I think all of these developments are documented, almost all of them, in the supplemental bundle. But I do ask the court to bear in mind what I'm going to come on to, which is the finality principle. The trial concluded in November. There were written submissions in December 2022. On the 24th of April, the trial...
So I think it's pretty clear from that, but just so as I'm not in any doubt, my understanding is that there were no oral closing submissions. Is that correct?
There were no oral closing submissions. There were short oral openings, which we have the transcript of, but they're not in the bundle. Very short oral openings. There were no oral closings at all. Evidence was concluded and closings were solely written. In some ways, again, that may be the source of some of our problems on both sides, because there wasn't the usual level of judicial interaction.
Yep.
So the draft judgment was circulated on the 19th of April this year, with the usual invitation to provide corrections and so on. Both parties submitted lists of errors in the usual way. There was no suggestion at that stage anything was amiss. The judgment was handed down, and the claimants, as it's their responsibility, take up the mantle of drafting the order. That can be found at tab 16 of the supplemental bundle.
Sorry, in the chronology it says defendants draft order. Is that wrong?
It is wrong, yes. The first draft order comes on 27th of April from the claimants. Yes, that needs to be corrected. Thank you. So this is the first draft order produced the day after judgment's handed down. And it states, on the trial on the issue of liability, and then there's a number of declarations relating to partnership issues. At F, we have the declaration at the time appealing, essentially the declaration that I'm appealing today.
I thought you said in your skeleton argument you resisted making the declaration, whereas this would seem to suggest you accepted it.
My lord, no, this is the first draft order produced.
So I'm sorry, it's the claimants.
Yes.
Sorry, we've just had that.
Yes.
Claimants. So
And we end up,
my fault. Yes.
we end up redlining it. There's a big argument, and
Yes.
the judge, in his discretion, decides to make that declaration. And I accept that's a matter of discretion, and I'm not challenging that. I'm challenging the substance.
Thank you.
So paragraph 1 of the substance, there's an inquiry as to damages for essentially what are now called the advertising breaches, the breaches of contract. And then there is paragraph 9. The claimants are seeking permission at this stage to appeal on breach of copyright. They are aggrieved by the decision on copyright. So even in this draft order, after trial, after judgment, they still think they haven't called to mind that they may have been the beneficiaries of an admission. They think they've lost. They think they fought trial on infringement and lost. That just goes to highlight the fact that this did not even play on the claimant's mind after June 2021. The following tabs go into the usual back and forth on the draft order. So tab 17 is the defendant's draft on the 4th of May. It's a red-lined claimant's draft. There's no substantial difference as regards copyright. I think we cross out permission to appeal, as in we would resist that. The next day, the 5th of May, Friday the 5th of May, is when the claimants come back with their draft. And this is the first time I submit that we get the reference to an admission, the argument that an admission has been made. And one sees immediately at tab 18 there is a lengthy recital about the admission. That effectively led to a series of short written submissions by email with the judge. There was no formal application from the claimant to amend the judgment or to revise parts of the judgment. It was all done in the context of arguing about what the draft order should say. And I'm going to come on to the judge's response now. But I've taken the court through the different stages of the proceedings, taken the court through different features of the party's conduct, and I suggest that taken in the round, the judge was entitled to find that the parties prepared for trial on the footing that infringement was a live issue. And as I say, he, as the trial judge, understood this better than anyone. He'd presided over, I think, all but one hearing in the last 13 months. If, and to the extent there had been any admissions, my lady and my lords, the claimants plainly elected not to rely on those admissions, not to run a case based on those admissions, including in their own particulars of claim, which they reserved many times. That leads us into the judge's decision at tab 29. And it's not expressed as a formal judgment for the simple reason that there was no formal application to him. But in essence, this decision which the cross appeal is made against. I've set out the legal principles quite fully in my skeleton on the cross appeal. In essence, I accept that the judge would have had a discretion to reopen the judgment, the barrel jurisdiction, as it were, after the judgment is given before the order is sealed. But that discretion has to be exercised in light of the civil procedure rules, in light of our usual adversarial system of justice, where you get one shot to run your best case at trial. And it was the claimant's responsibility to do that. It wasn't Mr. Greger's job, it wasn't my job, Ms. Hadkiss's job, or the judge's job. The claimants were ably represented, and they had numerous opportunities, which I've taken the court through, at which they could have put their hands up and ran an admission point. And instead, they actively put forward evidence from Mr. Mitchell on the topic of infringement. They had multiple rounds of written submissions. Either they genuinely believed that there had been no operative admissions, or they had it in mind but they dropped the ball and they forgot to mention it. And either way, it's not a responsibility of the trial judge or of my clients to pick that up. And it's certainly not a good reason to revisit the judgment. In my skeleton argument, I cite a case called Nigerian Airports Authority, and that is the leading case on judicial reopening of judgment after handing it down. And in essence, the principle it establishes is that this is a matter of discretion, but one needs very weighty reasons to overcome what the Supreme Court described as a dead weight of the finality principle. In this case, Mr. Kimbell, King's Counsel, had ample experience of the case. He'd considered the submissions made to him, and he concluded that there was no good reason for revisiting the findings he'd made at trial after hearing the evidence. I submit he was entitled to reach that conclusion, and he was entitled not to reopen that judgment. And on that basis, my lady and my lords, I respectfully ask you to dismiss the cross appeal.
No, thank you very much. Yes, Mr. Davis.
Thank you, my lords, my lady. Perhaps I can start with Moylan and Friends appeal, and just perhaps give you a bird's eye view of where I'm coming from on that. And it really can be done, I think, in 4 points. Firstly, we are not a million miles away from each other on the state of the law. Copyright can subsist in what I pronounce as a GUI, a graphical user interface, and in particular one looks at paragraphs 97 and 98 of Navitaire. Secondly, that was developed in the BSA case, where they move on to the more European formulation of author's own intellectual creation. But the court made very clear it's really a matter for the individual states as to precisely how they want to conduct that exercise in any particular circumstance. Thirdly, the look and feel, or author's own intellectual creation, were clearly elements to which the judge addressed his mind when considering the evidence that was given. And then fourthly, on that evidence, it was entirely open to the learned judge to hold that copyright subsisted. And your lordship, your lady, ought not to be interfering with that. Just perhaps first on the case law, before I go into those 4 points in a little more detail, but you have my fairly ample skeleton. I did want to pick up on paragraph 57 of the SAS case, which my learned friend took you to, really to say that my submission would be that the way my learned friend put it was rather out of context. SAS, as you may know, was an extremely complicated case, but one of the cases that consider to what extent the law of copyright can be used to protect the way in which, let's put it this way, computer software works. Now, what I understood to be the case of paragraph 57 was it's in a section, perhaps I can, sorry, we're tab 6, and I'm starting at page 248, and the section really is protection of the manuals.
Exactly. It was all about trying to protect the functionality by the route of a claim to copyright in the manuals. Right.
Well, I think Lord Justice Arnold is ahead of me from the point I'm trying to get. My learned friend was in my submission taking out of context the last paragraph 57 about choices and selection are choices of a kind, but they're choices of the wrong kind to be protected by copyright. Perhaps in view of the judicial comments, moving on from Navater and indeed moving on to the BSA case, and in view in particular of the helpful email from Lord Justice Arnold earlier this week, it is worth looking at the latest judicial pronouncement on artistic copyright in a GUI since we have it. And I handed that case up earlier.
Well, it wasn't about artistic copyright in the GUI, but it was about basic principles as to originality in this general context.
It was. I mean, that particular aspect of the right case is a complex attempt to, as I understand it, claim copyright in a structure of a work.
It was another claim to copyright in a file format.
Yes.
And they were trying to get around the problem that had arisen in SAS.
Yes.
By pleading it as a copyright work in its own right.
Right. But just turning perhaps to your Lordship's judgment in and paragraph 55, your Lordship looks at the InfoPack decision, goes on to say that the Court of Justice elaborated upon the requirement that the work be the author's own intellectual creation, a number of subsequent judgments. What is required is the author was able to express their creative abilities in the production of the work by making free and creative choices so as to stamp the work created with their personal touch. And you go on to cite a number of cases, in particular Painter and Kimbell and the others. Your Lordship makes clear at the top of the following page, this criterion is not satisfied when the content of the work is dictated by technical consideration, rules or other constraints which leave no room for creative freedom. And then one of the cases cited is indeed the BSA case. One of the points I would get out of that is the I'm labelling it as an exclusion, but it may be the wrong way of labelling it, to dictation by technical considerations, is that it's a very narrow exclusion, and as Lord Justice Arnold puts it, leave no room for creative freedom. I want to turn, perhaps, and I'm skating over a number of issues, but perhaps I could turn to the evidence as addressed by the judge. Now, what I've attempted to do here, because so many people have told me to do it so many times, is take my best points and leave the others behind. And in so doing, I'm really pinning my colours to the mast on two elements of cross-examination. And I believe they're elements that actually we've looked at before anyway. But I'm in the supplemental bundle. I'm at tab 4. And I'm page, let's pick it up at sort of 72. Now,
Sorry, pick it up at?
At page 72.
Thank you.
Bundle. And as the court have already commented, initially the cross-examination is concerning passing off. Also, as we move on, the court will be clear that what the witness is keenest about is to explain how awfully clever all the functionality is, but that's not the issue that the judge wants to hear evidence on. So we get cross-examination on transcript pages 297, 298, in which what the witness is saying, what's clever is about the price chart and the way it cross-populates, etc., etc. And in particular, I don't know whether you're, I think it's line 6 of 298. I don't know if you're saying this, the table of the figures on the left plus the chart is what makes this unique. That's the special feature. And he goes on about the cross-population. And the judge then interrupts at that point at 299. And his question is this: can I just ask a question about the origin of some of the tiles and tabs? I hesitate to say, but is there any, did you build it in any way on Microsoft? So it's in my submission clear from the judge's question there that he is trying to address or have the question addressed in evidence as to what did the witness do in putting this all together. And he continues on the questioning, did you use an off-the-shelf product? And the answer he gets further down on page 299, transcript page, is yes, it was from a library. The individual components
Sorry, which line is
are
this?
there. Sorry, I'm line 14.
14, okay, yes.
There are many libraries that I purchased, or THJ does. Skipping on a bit, the components individually in the library. So there's a splitter that runs down the middle between the option chart on the left and chart on the right, which you can drag. Behind the scenes, it's a library doing what it wants to do, but the look and feel is my brainchild. Now, what I get from that, or what I say the judge was entitled to get from that, is effectively, one could put it like this, there's a bucket of components that someone else has done, and he's selecting which he pulls out and puts on the screen.
Is that the sort of the extent of the evidence one normally finds in a case to support the creation of an artistic work?
I think the answer to that is, if I was running it, no.
It's quite limited.
It is extremely limited.
And could be said to be quite superficial.
It also could be said to be quite superficial. However, what I get is this, that if one was cross-examining an artist and they held up a piece of paper and put a squiggle on it, I wasn't looking, that's an artistic work. So the level of, the amount that goes unsaid in the creation of a painting or a doodle or whatever is such that the evidence one would present would be extremely limited. When one looks at what happened before Mr Justice Pumphrey in Navitaire, it was the first time a GUI had been litigated. And one would expect the claimant attempting to establish rights in a GUI for the first time would rather go to town on it.
Yes, I mean, there's no functionality in the squiggle.
There's no
Could be.
functionality.
I mean, it depends on what your... But let's say this is about functionality as against creativity. Or, but perhaps not as against, but the elements of functionality. What's dictated by functionality?
I accept. I mean, one of the ways it was put in Navitaire, it's not so much functionality. It's more author's intellectual creation. Is one can take out of the bucket almost a block of 4 buttons and put it on, and of course that wouldn't be the author's own intellectual creation because it came as a set. And what happened in Navitaire is they needed to go further and say, well, that came as a set, but other things were individual. But the answer I'm trying to get across, and it is different people run their cases in different ways, and there's proportionality, etc., is that the concept of there being copyright in a GUI would lead to cases being run these days on rather more of an assumption that copyright was there, but clearly it remains the claimant's task, if challenged on it, to prove it.
You also rely, I assume, on the answer at page 300, line 90.
I also rely on the on that answer, and again, I think to answer Lord Justice Moylan's question, clearly the fact that I'm relying on cross-examination and not evidence in chief answers the question as to whether one would expect rather more evidence in chief than there was. And I think I have to hold my hands up to that and say, had the cross-examiner not chosen to stray into this territory, I would be struggling for supportive evidence. But they did, so I'm not. Lord Justice Arnold's already identified, I think, my second best portion. I can rely on all sorts of other less strong arguments, but I anticipate that may not be helpful. I think I can only put it like this. It is a hurdle that a claimant needs to get over. It is not, due to established case law, a particularly high hurdle, but it is one that is there. Also, at the end of the day, the question for your lordships is not whether you would have decided the case in the same way, but whether there was sufficient evidence for the judge to decide that.
Can I ask you about that? Because the case that's put against you, as Mr. Ludlow was very clear about in answer to the question from my Lord Justice Moylan, was he puts his case on 2 bases. Firstly, he says the judge applied the wrong test because he did not ask himself the right question, namely, is this the author's own intellectual creation, etc. Secondly, he says, therefore, we have to look at it ourselves, and there's no sufficient evidence. Now, you've just been addressing his second submission. You say there is sufficient evidence, but what do you say about the first submission, namely that the judge applied the wrong test?
Well, let's look at that then. The first point I have to put on that is comes from the transcript at 299 before we even get to the judgment, as to the questions the judge was asking the witness in cross-examination, give some indication of the test to which he would, going forward, address his mind. So that's the first of those points. I then turn, I think, I have to turn then to the judgment, and that's tab 6 of the core bundle. Perhaps I can so picking it up at paragraph, well, the core bundle 108, the judge starts looking at copyright, paragraph 201 of his judgment, and it's really Roman 2, the one software produces images including but not limited to the risk and price charts, and each image is an artistic work within section 4. He sets out in 208 the aspects he's looking at, aspect 2 and 3, the GUI and the screenshots. As I understand it, the only real difference between them is the GUI is effectively what the software is producing, and effectively the screenshots is what is then being used in the YouTube videos, screenshotting a snapshot of that GUI. So to a great extent...
I may be misunderstanding, but I think what judge is meaning is the GUI itself is what you get presented with before you start inputting any data. And then the screenshot is the GUI in use,
yes,
i.e. with some data in it.
I think that may be, I accept that correction. I think that may be a better way of putting it. And what I'm trying to look at is the GUI in operation, the screenshot. And I accept, and I know it's a common feature in copyright cases, that it is important to identify the work with precision. And that cannot perhaps be said to be done particularly well in this case. But nonetheless, the parties were, I'll go into some Latin, ad idem as to what they were talking about in this respect. And in particular, the screenshots, the YouTube extracts that we have in the supplemental bundle. I'll move on then. The judge picks up at 212 that it was not disputed that the individual frames were in principle of constituting artistic works. However, they don't qualify automatically. So clearly the judge addressed his mind to the fact that something further needed to be proved before he could find there were artistic works. And then he looks at the Nova and Mizuma case, and he talks about in that it's the design of individual graphic components. We don't actually have that, but in Nova and Mizuma I think we also have items taken from a library. And then at 214, in this case, the evidence as to creation of the graphic interface was rather limited, entirely correct. At trial, Mr. Mitchell's evidence was he'd obtained the components that are displayed on the end user screen when the software is in use from a third-party library. So the judge is fully aware that these elements have come out of a bucket and they're not author's own intellectual creation in themselves, but that he was responsible for the overall look and feel display. So my submission, the judge is addressing his mind to, and I don't think it helps paraphrase what might be meant by look and feel, but the look and feel. He goes on to say, I'm satisfied that the work in creating the look and functionality, including the arrangements of the tables and graphs, well, I accept the word functionality is there. It does not, in my humble submission, make enormous sense as to why that word is there. But nonetheless, what the judge is, when the judge is narrowing it down further, he's looking at arrangements of tables and graphs. So he's looking at how things are arranged. Although on 215, on 215, again, when one gets, as was raised by the court, drills down so as not to be too glib, the last sentence there, the same is true of the overall look, framing and layout of the graphics and tables. So my submission, it's clear that that is the lowest he gets on exactly what he's looking at. And in my submission, he's looking at the right elements of skill and labour. Although he has moved on to some extent by that time, it is worth noting that the judge does look at, when he's looking at whether there's infringement of source code, he does cite Coppinger at the top of bundle page 113, to say that merely reproducing the functionality of another's program by observing, studying and testing the behaviour does not make use of the protected subject matter. Now, I'm not saying that that's the same point. It's not even perhaps a closely connected point, but nonetheless it shows an understanding that functionality, reproduction of functionality, is not something that falls within the realms of copyright law. Perhaps the last point I can make on this is the judge's reference to 214 and the fact that in finding for subsistence, he says that the analogy with the GUI screens in issue in Navitaire and EasyJet is, in my judgment, apposite.
Sorry, which paragraph?
I beg your pardon. It's the end of paragraph 214.
Sorry, thank you.
Flitted around rather.
Yeah.
It is clear when one looks at the closing submissions that the judge was taken in some detail to the Navitaire case. The Navitaire case, whilst, as has been observed, things have moved on a little with from skill and labour to author's own intellectual creation, nonetheless shows quite nicely between the BT100 and the GUI screens just where perhaps the boundary falls.
Well, not really, because the point made by Mr. Justice Pumphrey was that one was a literary work, in essence, whereas the other was an artistic work.
Well,
yeah, despite the fact that there was a tiny element of artistic layout in the VT100, it was essentially a literary work. Whereas the GUI screens, although they had informational content which would be in principle within the scope of the literary work, were primarily artistic, because it was all about the layout.
I'm not, with respect, I'm not sure primarily is the right way to analyse it. One looks at the VT screens and they can be both a VT100, they could be both a literary work and an artistic work. And the judge held that insofar as they were alleged to be an artistic work, the artistic content was trivial. Whereas the GUI screens, Yeah, whereas the GUI screens, again, would be both. It depends which one you're which one you're alleging. But I mean, the rejection of the claim for artistic copyright on VT100 seemed to be very much on the basis, and the judge uses the word quite a lot, that they were trivial. Yeah. Now, I do accept that the formulation of the test has changed slightly, and I do accept that I think in SAS and perhaps some other announcements in the Court of Appeal have said that the European test might be a bit higher, but no one has yet said that, yet identified where it makes a difference. And I don't understand this case to be put on the basis that it makes a difference. My lords, I have flitted around rather in attempting to answer the case as put rather than just repeat my skeleton. Are there other aspects of my resistance to the appeal upon which I can usefully address you?
No, thank you very much.
Right. That brings me then to the cross appeal. I wanted to take this, if I can, in two stages. Firstly, looking at what admissions we say were made, and then secondly, responding to the case as put. I've put it in the pejorative way that it's all too late, but the other way of putting it is finality principle. I know I do need to address that. Perhaps I can take you first to the pleadings. And if I may, and hopefully it was a helpful way of doing it, take you to the annex to my skeleton, which is to be found, it's in the core bundle, tab 16, and it's right at the back, and hopefully there's a sort of coloured copy that sets out the particulars, the defence, and the reply. What this doesn't do is say exactly when they got there, but in my submission that doesn't really matter because the final pleadings are the final pleadings and they're the case that was advanced at trial. So I will be slightly repeating what's already gone, but let's do it perhaps anyway. Paragraph 38 of the particular claim, we have the plea that the software was created by Mr. Mitchell, and then at 38.2 we've got the images including but not restricted to the risk and price charts, and that's why I've concentrated on the risk and price charts, because that is the most definitive definition of any work. And we've got there the plea author's intellectual creation and they're an artistic work. The response, as we've already established, is that there's the first denial that the risk and price charts are the intellectual creation of Mr. Mitchell. Secondly, that even if they are artistic works, then, and I'm at the bottom of sort of first hole punch of page 235 now. Secondly, if they are copyright works, that the copyright owner is effectively the user. We then get some specifics at paragraph 40, and we have the two presentations that are relied upon at 40.1 and 40.2. And there's a reservation of rights basically saying, here are two examples, we reserve the rights to plead more, if we need to. The response to that is that, that it's admitted insofar as they relate to the use of images generated by the software. I'm aware that the word use is capable of interpretation. The defendant's position is the question of whether or not copyright subsists as a matter for trial of liability and can be determined on a pleaded example. Question of extent of use is a matter for trial of quantum, and if liability is found, the defendants will provide disclosure. So what I say we have there, insofar as those examples are concerned, is effectively the admission that this is all going to be about, are they artistic works and who created them? And we can do that on the basis of the two examples we have in the pleading. And if you get home on those, we'll sort it all out later. We then actually get the meat of the plea as to why this is an infringement of copyright over and above just the word use. And at 42.1, there's the plea of communication to the public. And the response to that is at 51B of the defence, and I don't think this is one that I've taken as yet, that you've been taken to as yet. As regards paragraph 42 and its subparagraphs, that includes the plea section 20, it is not understood how the reproduction or the distribution of images amounts to use of the source code. Good point, that one went away. In the circumstances where it's denied that the pleaded images generated by the software are capable of copyright protection, it is denied that the defendants or either of them have infringed any copyright. So again, or not again, what I say we get from this is a denial of infringement of copyright on the basis of lack of subsistence of copyright. I'll give them ownership because they've raised that before, but my submission is there is an explicit denial of infringement. It's requirement under the CPR 16.5 to say out the basis of that denial. And it is very plain that what was in dispute, and I know we've looked at this, what is in dispute is subsistence, ownership, and perhaps the license point, though that may have gone away at some point. And by the license point, I mean exactly where in time they were used and whether it was before or after termination of the partnership. Just to finish, perhaps, just before the short adjournment, on one of my weakest points, in the reply, we take a cheap point, which is a bad thing to do in a pleading, that we make no admission as to 51A and 51B, which they find impossible to understand. Well, in my submission, they're not impossible to understand. They are clear, and they make clear what the fight is going to be about once we get to trial. So that's the pleading admission point. Second point I want to take is on the Daniels witness statement, but perhaps, unless I try and squeeze that into 3 minutes, that might be a convenient moment.
Certainly, yeah, we'll start. Excuse me. So starting at 2 o'clock.
Yes.
How much longer do you think you might be?
I'm hoping to be not more than 45 minutes.
Thank you.